with an administrative judge, preparing and submitting your discovery requests, responding to the agency's discovery requests, any motions that might occur during that discovery period, and preparing for depositions. Next slide. So to get to the discovery phase of your complaint, you must first have gone through the informal and the formal complaint processes, which in the formal complaint process includes the investigative phase. You will have already received an acceptance letter of acceptance of your claims by the agency for investigation. The investigator will have already contacted you. You've already done your affidavit, submitted documents, and the report of investigation, which is the culmination of that investigation, will have already been sent to you. When that report of investigation is sent to you, you are given an option to file a hearing request to have a hearing before an administrative judge at the EEOC. Your hearing request must be filed within 30 days of receipt of that ROI. By electing to have an EEOC hearing, you are starting the process of being able to obtain information from the agency through discovery. At this stage, the agency will have an attorney representing the agency. And so you can expect to have correspondence with that agency attorney. Next slide. So after you file your hearing request, and you should do so on the EEOC portal, complainants portal, most likely the first thing you will receive is something called an acknowledgment order. The acknowledgement order typically comes between 3 to 4 weeks after requesting a hearing. Depending on what field or district office you have filed your complaint in, depends on the speed at which you may get something. I should just say this as a blanket statement, all orders that come from the administrative judge or the EEOC, you should review very carefully because they differ judge to judge. So just because one judge has something in here, or generally this is the practice that I'm going to go over, doesn't mean that another judge that you get assigned may have specific requirements or different procedures that you have to follow. You have to follow what is in the judge's order. But the acknowledgement order is typically what comes first. And this order is very important as to your cases. It defines the timelines and the deadlines that the judge will set. And it will designate, if it hasn't already been designated by the commission, a file number for you. Most likely in the acknowledgement order is going to be something called a preliminary case information sheet. Preliminary case information sheet is the document that the EEOC has been using so that the administrative judge can get an idea of what is going to happen during the initial conference. Were there any claims that were improperly dismissed or properly dismissed at the investigative stage? Are there MSPB complaints that are kind of companion to this? Are there any other complaints that are companion to your case? And then what information generally you are seeking at the discovery phase? Those are all pieces of information that you would need to complete in that PCI, preliminary case information sheet. It also has a designation of representative form. If you are unrepresented, you complete the form with your contact information. If you are represented, your representative will complete that form. Next slide. I got ahead of myself here. Here's the preliminary case information sheet right here. As I said, there are 5 categories on this form, identifying the claims that have been dismissed, if there are any additional documents. Now, this is an important thing because this is what starts the process of thinking about discovery. During the investigation, the complainants have very little control over what is actually sought from the agency, what questions are asked. Actually, the complainants have no control over that. It is up to the investigator to ask those questions, the investigator to get certain documents from the agency. And in majority of cases, there is information that as a complainant, we would still want that wasn't gathered during that investigation. So those are documents, and typically these are documents that are correspondence between responsible management officials. Those usually are not in an ROI. Background documents, drafts of proposed disciplines or proposed letters or something, those are typically not in there. A lot of times comparator information is not in there. So these are all things that you're thinking, okay, what do I need that the agency has yet to provide? And you're identifying documents that you want the agency to provide, not documents that you have that you would want to provide. You get to do that when you want to. You're looking at, what do I want the agency to send to me? And that would be additional statements too. If you sent the investigator a list of witnesses that you wanted interviewed, and they didn't interview any of them, or they interviewed one of them, and there are additional people that you think should be, that information should be sought from, that would be a list of people. Additionally, in my experience, most people, I have more questions for witnesses than are asked during the formal investigation. So I would want to do some follow-up questions on a lot of the people that are interviewed. And that would be an additional statement. And then, like I said, if there was an MSPB appeal or if you filed a grievance, the judge is looking for companion cases that might be associated and might delay the processing of this complaint. All right, next slide. So after you file your PCI, and typically I should say those are due 15 days after receipt of the acknowledgement order. Again, please read the order. Those deadlines will be set out in the order. Most likely after that, the PCI is filed, you'll get an order scheduling the initial status conference. And this will be with the judge who's going to litigate your case most of the time. There are a couple field or district offices where the supervisory judge does the initial status conference and then later assigns a judge, but in most cases, this will be with the judge who is going to adjudicate your case. And the judge will set a time for you, your representative, if you have one, and the agency representative to meet on a conference call. Again, most of the time, the conference is just procedural. Going over what the claims are, making sure everyone is on the same page as what the claims are, discussing whether there were any dismissed claims, and kind of the timing and progress of the case. However, there are times when opposing counsel might want to discuss some pre-hearing motions. The judge may treat it as kind of a pre-hearing conference, meaning going over substantive issues. The judge also may go over the claims and ask questions about the claims and clarity of the claims. You need to be prepared in this call to be able to discuss what your claims are, what your bases are. And just so we're clear, bases is the protected bases, that you're alleging discrimination on the basis of sex, race, age, etc. And you need to be prepared to discuss those and specifically what your claims are. Most likely, you're going to find a list of your claims in that acceptance letter that I referenced earlier in your report of investigation. If the claims are not correct on that acceptance letter, you need to talk about that and say why they are not correct. But the judge is going to go over that. The next thing the judge is going to do is ask you about discovery. Some judges are very specific about what discovery you're seeking, and some judges just want broad strokes. So some judges want you to almost literally walk through specific requests. And some judges just want, okay, you're looking for email communications, you're looking for comparator information, etc. The PCI is the tool to help you really organize your thoughts on what it is you're looking for in discovery and be prepared for that. So I would have that available during the initial status conference to really go over what isn't in the ROI that you still need. And based on that conversation, the administrative judge is going to set limits on discovery if they grant discovery. And those limits are how many types of requests you can ask for. So there are 3 types of requests that you can seek from an agency during the discovery phase. The first is what's called interrogatories. Those are written questions that you want the agency to answer. They can be things like identify all people who have information regarding the claims in this case, or it could be far more specific, like explain every which reason why the notice of proposed suspension was issued. Things like that. They do need to be defined enough to a specific time and a specific person or people or division of, usually it's your supervisory chain or people within that. That's the first set, written questions called interrogatories. The second type of request that you can make are called document requests. And these are, again, documents that you think the agency has in their possession that you want produced. It's also you want to ask for things that maybe you don't know exist, but you want to have an idea of what the agency is going to present as evidence at the hearing. You don't want anything to be a surprise. So you ask for documents that the agency might use at the hearing. And you do those in very specific requests. And then the final is called requests for admissions. Requests for admissions are single facts that you think the agency should admit to. Admit or deny that complainant is a protected basis, is female. Single facts that you think should happen. Admit or deny that RMO issued proposed removal on this date. Things to that effect. And so the judge is going to set the number for each category of requests that you can have. The most is typically 30, 30, 30. Some judges like to do 20, 20, 20, but that is up to each administrative judge. I only use what we need. So even if I get 30, 30, 30, if I only have 26 questions, I'm going to only ask 26 interrogatories, right? But you have to pay attention to those limits set. The other thing the judge is going to do is define deadlines. A lot of judges define a deadline as to when you have to initiate discovery. Now, this is critical because in a lot of judges' orders, it says that if you do not initiate discovery by this date, you have waived your right to it. So it is incredibly critical that you do that. This also includes for noticing depositions. And we're going to talk about depositions later on in the presentation, but that has to be, your notice of deposition has to be included in your discovery request under most circumstances. Again, it's very specific to each judge's order. Some judges are more flexible about when you can request depositions. They can be after discovery responses, but some judges need it to be when you initiate discovery. And when all else fails, the safe thing to do is to request depositions at the beginning when you initiate discovery. Then the judge may set deadlines for responses. Typically, responses are 30 days after you initiate discovery, but sometimes judges like to set specific dates. Some judges like to give more time because they understand that there might be a lot of electronic sources that the agency is going to have to look through. So if you're requesting emails, they might have to go into other people's email boxes, pull data, et cetera. So they might give a little bit longer, but typically it's 30 days. And then there's an ultimate conclusion for discovery. By this date, all discovery must be complete. And so you're going to want to make note of that. Most likely the judge is also going to set deadlines for dispositive motions, which we will talk about later in the presentation. But this whole frame of the case in terms of deadlines is going to be set typically at the initial status conference. Sometimes judges set dates for pre-hearing and hearing, but not all judges do that. So you want to have your calendar available to you when you go to an initial conference. All right, next slide. So preparing your discovery. It is arguably, like I say here, the most important stage of the case because it is the opportunity to get as much information possible from the agency related to your claims. If you're going to hearing, you need to be able to prove your claims, and discovery gives you that opportunity to, one, have the evidence to prove your claims, but two, also understand the evidence the agency might be relying on to defend their actions. So this is the opportunity to get all of that. Typically, discovery lasts about 90 days. It can be extended. The procedures for requesting any extensions are usually found in either the Acknowledgment Order or something that is issued after the initial status conference called the Case Management Order. And the Case Management Order delineates those deadlines like we discussed, and then the procedures for filing a motion for an extension of time, a discovery, or filing motions to compel, et cetera. Again, review I can't stress this enough, review every single order the judge issues. So when you're drafting your discovery request, you want to think about, okay, what do I need to prove my case? What am I missing that would help me do that? And you need to be specific in your requests. You can't just say you could, but you'll probably get an objection, all documents that relate to my case. That's not specific enough. You need to have specific people's names, their dates, their positions, and then you need to reference dates or date periods. Typically, a 5-year span is considered the realm of reasonableness for a search. Sometimes it's less, sometimes it's more, but that's about what might be reasonable. It could be more, though. It could be less. Sometimes if you've only been at the agency for a year, that's probably going to be the realm of reasonableness. Remember that you still have the report of investigation, and you can refer back to that in your discovery request. So if there's a comment that one of the RMOs made that is unclear why they're saying that or where they got that information from, ask about that, right? Say, you know, RMO Smith, I want him can explain what he meant by X or what document he was referring to when he said this, and you cite to the ROI page. Or you say, it appears that there is an email chain in the ROI and there are attachments, but those attachments were not included in the ROI. Provide those attachments in the complete email chain. Go back. That's one of the best ways to reference things is you can see what was left out that is referenced in the ROI. You're trying to uncover what information the agency is going to rely upon. However, discovery is not a fishing exposition. You have to be narrowly tailored enough that it's not just casting, you know, a net for any and all information. You have to be specific, but it is our opportunity to find as much information as we can. And that's kind of the fine line you have to walk in discovery. Remember your deadlines when discovery is due. After the discovery period ends, any information that was in your possession or that you failed to ask the agency for that might have been in their possession probably isn't going to be able to come in. So you want to get as much information in as possible during discovery. Now, if the agency fails to ask you a question, they fail to ask you for some documents, like they fail to ask you for any and all medical evidence, you don't have to provide it. You can provide that later. But anything that they ask for, any documents that you have that are responsive to their request, you got to submit at that time. And anything that you could request at that time, if you don't, you may not have access to it at hearing. Okay. All right, next slide. All right, so after you submit your discovery responses, most likely to agency counsel, they are likely going to turn around and send you agency's requests as well. And that will start your clock on providing responses to those requests. You can object to certain requests by the agency. Proper objections could be related to privileged information, relevance of information being requested. You know, if they ask you for, you've been at the agency for 3 years, but they ask you for all of your records from your 15 last jobs, you know, that's not really relevant. You can object to that, and that's not reasonable. You can object to a question that's vague or not specific enough and say that you don't understand what's being sought. Those types of objections you can make. You can also indicate if the information is already in the record. So if they want you to explain why something is discriminatory, most likely you were asked that question at the investigative state and it is in your affidavit at the ROI. You can always say, please see my affidavit at ROI page, whatever to whatever. And you have to have a citation, but you can reference back. Or if you already provided documents in the ROI that relate to what they're asking, so provide all your time cards, and you already provided that, you can say, all right, those can be found at ROI page, whatever to whatever. So you can reference back. You don't have to reproduce things that are already in the ROI. This is your case, so you should be the first one to draft your responses because ultimately they are your responses. This is kind of like step one for testifying, right? These have to be things that come from you. If you have a representative or an attorney, they're likely going to review them, revise them, make suggestions, etc. But this has to be your response because we get to a deposition, we get to a hearing, the agency can ask you about that. Is this what you said? And it can be treated as a statement. So it needs to be from you. But work with your representative on providing that narrative towards your responsives. What's the way to frame things? What information is being requested is a big part of the analysis. You don't have to provide things not being requested. You can if you want to, but you don't have to. So you can walk through that analysis with your representative. And remember, when your discovery responses are due back per the scheduling order or the case management order, most likely what it will be called. Because if you are late for your responses or you fail to respond, The agency could file a motion and seek responses. And if ultimately you are non-responsive, the ultimate sanction for failing to respond is to have your case dismissed, which is one of the sanctions available, usually outlined in an acknowledgement order or in the case management order. So you have to respond. Next slide, please. Motions during discovery. Now, let's say you get back responses from the agency and they did not respond to half of your questions at all. They just make objections and they didn't give any substantive information. Now, this is different from an answer that you disagree with. If you disagree with an answer, so if you say, provide all communications between these two RMOs, and they say there are no communications between these two RMOs about this topic for these date periods, whatever parameters you had put in your question, that's different than not providing anything. So if they object and say the question is too broad, it is unduly burdensome, and it is vague, therefore the agency is not going to provide any information, then you can try to seek that through a motion to compel. But just because you disagree with an answer that the agency gives, you believe it's false, you believe it's to be untrue, you believe to have evidence to support that, that is more getting into proving your case at a hearing, not what is responsive in discovery. So you want to review the agency's responses to make sure that they did respond. But let's say they didn't respond to half of them. They just completely left them. Then you have to do what's called a meet and confer letter, email, or you have to call agency counsel to meet and confer on these issues. Now, again, I'm probably going to say it about 50 times during this webinar. You have to go back and look at the judge's order on how you are supposed to handle discovery disputes. If you have, sometimes judges are very formal in the process in that you have to do a meet and confer with the agency and then you file a motion to compel. Some judges require that you have that meet and confer process, but then you have to email the judge and the judge wants to talk about it before anyone files a motion. Whatever the process is that the judge is going to delineate in the order, you need to follow that. You also have to look at timelines. So the agency can dump thousands of pages of documents, but the timeline for when you have to notify them is typically, or to file a motion to compel is typically 10 days. It is a quick turnaround. So you have to do a sufficiency review of discovery pretty quickly after you receive the responses. Now, everything I'm saying is true on the other side. So all of the requirements that are on you during this phase are also on the agency. So when you produce your responses, they have to do the same thing. They have to do a quick turnaround, they have to review, and they need to contact you within the parameters of the judge's order. In all circumstances, you have to try to work out the issues in discovery with the agency. So you have to say, hey, agency counsel, I see you didn't respond to interrogatory 4, 5, and 7. Can we talk about why you didn't respond? Maybe I can clarify the question for you and see if we can work this out. You have to try to have that conversation. And I think it's best practice to try to document that conversation. So if you have a telephone call about it, follow up with an email saying, hey, in the telephone call, we discussed this, this, and this. You told me that by this date, you're going to supplement your response, and I can expect that. And that way you have documents that if you have to file a motion to compel, you can have that as supporting evidence. Oh, I did meet and confer. We did talk about this. The agency promised me that they were going to supplement their answers, and then they failed to do it. So after you try to meet and confer about these, then you need to let the judge know either in a formal motion or in the email to the judge what the problems are. And I find it best to put in the specific request, what the agency actually said, so what their response was, and then why that's deficient. It's deficient because all they did was object and they didn't have a good objection. It's deficient because they failed to answer the actual question. I asked for when, why, and how, and they only answered when. So they forgot to answer why and how, and they are not agreeing to supplement. Or, as the example says, the agency failed to provide copies of the requested documents and emails issued by John Smith dating back to October 1st, 2021, they didn't provide anything from John Smith. So that would be a deficiency. Most likely, even with a filed motion to compel, the judge is going to want to hold a call. A lot of administrative judges like to hold calls to discuss these issues with the parties, because most likely they're going to come to some sort of compromise. So the agency will get to say why the request was unreasonable or why they think they did actually respond to it. And then you're going to get to say why that's not sufficient. And the judge is going to most likely in that call make a ruling as to what needs to be provided and when. A lot of times you need to request an extension if the motion to compel goes beyond the deadline of discovery. You want to make sure that the discovery period is elongated so that you can get all the information during discovery. There is the possibility that you could request sanctions against the agency if the agency fails to comply with the motion to compel. I would make a blanket request, not a very specific one, and see what the judge is willing to do. Some judges are willing to provide sanctions. I shouldn't say there are some judges that are never willing. I'm sure under certain circumstances, any judge would provide sanctions, but some are more willing than others to provide sanctions when the agency is just failing to cooperate. All right, next slide. All right, depositions. So far up to this point, we've talked about what's called written discovery, written responses. But depositions are outside of written discovery. And this is the opportunity that you have or your representative to question critical or needed witnesses or responsible management officials about specific facts in your case. I like to figure out what people I need to depose after I receive the written responses. If there's information that I'm still missing after written discovery from the RMO where they failed to provide it, I'm going to take a deposition. However, depositions are costly because you have to have them transcribed. So you have to hire a court reporter and you have to have a transcript produced. If you are the person requesting the deposition, you have to pay for the court reporter and the initial copy of the transcript. Now, if the agency notifies you that they want to take your deposition, they have to do that. They have to hire the court reporter and they have to pay for the initial copy of the transcript. You can buy a copy. The agency is in all circumstances, I shouldn't say all circumstances, most likely will be allowed to take your deposition. Depositions are used for a variety of ways and reasons, but particularly it's to discern testimony prior to hearing. So there's a general rule about hearings and trials that you never ask a question that you don't know an answer to. And the reason why you know the answer is if you ask that question during a deposition and you see how the deponent answers the question in a deposition. You also in a deposition get the opportunity to ask background information that you wouldn't otherwise be able to ask at a hearing. So you can ask about an RMO's employment background. You can ask about their education background. You could ask about any complaints ever been filed against them, even though that's not necessarily relevant. It could lead to relevant information. That's the standard for discovery. So it's a wider scope that you get to do in a deposition than you get to do in a hearing. My typical rule of thumb on who do I depose are not friendly witnesses. If you have someone who's a friendly witness, most likely they're going to be able to provide you an affidavit or they're going to be willing to talk to you about it. Not friendly witnesses, and this isn't to say that you're actually enemies, but people who are in the case put against you. So those RMOs, there's responsible management officials, witnesses who agreed with management let's say you have an affidavit from a coworker who agrees with the supervisor about what happened. You can depose them. People who are not going to be on your side, or you think might not be on your side, and it's unclear. Those are people from whom you can seek information. Those are who I would depose. Now, some people you don't have to depose because you have all the information in there in the ROI or it's in the written discovery. But other people you want to clarify some things. Those are the people I would depose. Like I said at the beginning, you typically need to notice those depositions when you initiate. But certainly you need to start scheduling them around the time that you get discovery responses, no later than 10 to 15 days prior to the close of discovery, because you have to be able to afford time to be able to schedule that deposition. There's no set time in the EEOC of what is reasonable time or reasonable notice, but 2 days is not reasonable notice. 5 days is probably not reasonable notice. So I would go 10, 15, at least 2 weeks kind of as for reasonable notice and scheduling. And scheduling can be difficult depending on what time of the year it is. You know, if it's at the end of the year, it's very difficult to schedule government employees because a lot of people take leave. The summer is also a difficult time to schedule government employees. So it depends on the timing of the year as to how much effort you're going to have to try to schedule depositions. Most depositions these days are now done in things like this, Zoom, Teams. They don't have to be in person. However, some can be done in person. So if you're all in the same location, you know, the same office building, you can have a deposition physically together, or you can have it via Zoom, Teams, etc. Zoom for government. Most of the depositions I do are a virtual platform these days. Things to consider when leading up to your deposition is to determine what your goals are for the purpose of having the deposition. Think about how this deposition or the witness will help you prove what you've alleged in your complaint. What questions and kind of put your mind into what a judge might be looking for at a hearing to prove your case. What would be helpful? And those are the questions you'd want to ask. I have a general principle of 5-year-olding. I call it 5-year-olding a witness. When did you do that? Why did you do that? Who was there when you did that? Why? What was the reason? What was happening at the time? What precipitated it? I ask questions as in all the information I could possibly get. Those may be questions that I don't ultimately ask at a hearing, but I want to ask those questions now to know if, oh, that's a dead end. I don't need to go down that road. I don't need to go down that road, but this is the road I need to go down. And you want to think about what specific facts you believe a witness to have. If you have somebody that you're deposing that was present in a meeting where an alleged comment was said, or they say that you did something, you want to ask about that specific event. They might not know, particularly if it's a coworker or subordinate, they may not know, you know, the inner workings of the discipline against you. They may not know about the PIP levied against you, but they know about what happened in that meeting because they were present. So you really want to hone in on what you think that witness specifically knows. All right, next slide. All right, so after discovery has concluded, there's no more issues. All of the documents or all the requests have been responded to. Most likely the judge is going to set, like I said, deadlines for dispositive motions. Dispositive motions are motions that decide the case. And one of those motions is a summary judgment motion or a motion for decision without hearing. Those terms are kind of used interchangeably. They all mean that the party, Taylor, go back. They all mean that the party presenting the motion believes that there are not material issues of fact warranting a hearing, and that the law is in favor of the filing party. Technically, anyone can file a dispositive motion. A complainant can file it. If you believe you have indisputable evidence and there are no material issues of fact at issue, you can file a motion for summary judgment. That is less likely and doesn't happen as much as the agency filing a motion for summary judgment. It's more likely that a defendant files, which in this case, in the EEOC cases would be the agency, than a complainant or a plaintiff. You want to go back and look at the deadlines for the agency to file. Most likely it's 15 days most likely it's 15 days or 30 days after the close of discovery. And the judge may not set dates certain. They may say 15 days after the close of discovery. They may say 30 days after the close of discovery, or they may say May 5th. You got to go back and look. Your response is typically the same amount of time. So if the agency had 15 days from the close of discovery to draft and file their motion, most likely you are going to have 15 days to respond. Similarly, 30 and 30. Sometimes it's a little bit skewed because of weekends or holidays and it goes to the next business day, but it's supposed to be about the same amount of time. So the agency files a motion for summary judgment, and there are going to be components of that motion, particularly a statement of facts not in dispute, material facts not in dispute. This you need to respond to fact by fact. They should be enumerated. The agency should be doing number 1, number 2, number 3. And you need to go into, as part of your response, and do admit, deny, admit, deny, admit, deny. And if it's denied, why? Why is it different? Why is it wrong? In addition to opposing the legal arguments that are contained in the agency's motion. The agency sometimes has the ability to file a reply. So that would be anything that's new, that's presented in the opposition that wasn't in their motion. They can reply to that. That's typically due 5 days after the opposition. Some judges do not allow a reply. Again, you got to go back and look at that order. The order will also, the judge's order, case management order, or the acknowledgement order will likely have very specific requirements for a pleading. So it may have a font size, it may have a margin, 1-inch margins. It may say how many pages you are allowed. If it says that you're only allowed 15 pages, and it'll define what it means by that, typically a statement of facts or exhibits don't count towards that page total, then you need to stay within that. Because typically if you don't, what will happen is the judge will not review anything after that page limit. If you need more pages, ask the judge prior to the deadline. You can't do it day of the deadline or after the deadline. Prior to the deadline for more pages and state why. You know, we had 3 depositions, Your Honor, in this case. The agency failed to talk about so many facts, and I have to walk through them all. There are 15 claims in this case that warrant a higher page allowance. But you got to pay attention to that, because if you miss that, the judge might not look at part of your argument. Pay attention to all of those requirements. The judges also may have specifics on filing. So a lot of EEOC judges require that not only do you upload it to the portal, but you have to email a copy as well. And that is because for complainants, the judges do not get notifications that something has been filed in the portal. So most likely you're going to have to notify the judge, hey judge, I filed the motion to compel. I filed my opposition to summary judgment. Here it is. So they have it. That's likely going to be a requirement in there. Some judges have very specific requirements of what can be in the body of an email, but again, you want to go over that and make sure you're covering all those specifics. After this process has been gone through, the agency files its motion, you do your opposition, maybe there's a reply, then it goes to the judge. The judge is supposed to determine whether there are issues of fact warranting a hearing, and if not, is the law in favor of the agency or the complainant. And this is one of the frustrating things, is there's no set timeline for when that decision needs to come. It can be any time after the filing. If you have a hearing set at the initial conference, likely the judge anticipates that it's going to be a faster decision, or they're trying to set a deadline for themselves. But I've had summary judgments sit for 1-2 years. I've had summary judgment decisions come a month or 2 after. So it can be really anything in that ballpark. Sometimes, particularly if the agency didn't take your deposition and, you know, there are points that you've always thought you wanted to clarify, but you were never asked the questions, you can write an affidavit for yourself, sign it, swear under penalty of perjury that these facts are true, on things you want to fill in as supportive evidence. Typical rule of thumb is that if you don't have a support in a document, in the ROI, in a deposition to support a factual statement, it's not support, you know, it's not going to be something that's going to be weighed as heavily. So you could add that into an affidavit after the fact. And then again, supportive witnesses, like coworkers, or people outside of your chain of command, you could always see if someone might be willing to do an affidavit in support of your case as well. All right, next slide. All right, settlement discussions. Now, I always talk about settlement as kind of a parallel track to everything else that we've just talked about. You're moving along this path through discovery. through the case, summary judgment. Settlement can also happen at the same time. Settlement can happen at any time. Typically, prior to the initial status conference, the judge is going to order you to talk to the agency about settlement. The judges like to discern whether a case can settle before you do the process of discovery. As you've heard, it's a very intensive process. It can be expensive. Depositions are expensive. So the judges want to know, okay, is there a possibility here that we can settle this, resolve this prior to beginning that process? And so they'll ask you, okay, complainant, you go give an offer to the agency, and the agency, you have to respond. I will say that typically it is complainant who goes first in that process. That is not a sign of weakness. That is not a sign that you're willing to give up your case. That is just the usual process. Now, the agency could respond, thanks, no thanks, and then it's not likely to settle, and then you move on. Another thing that an administrative judge can do is order you to ADR, alternative dispute resolution, or mediation, or a settlement conference with a settlement judge or EEOC mediator. Depending on what field or district office you're in, it can be another administrative judge or someone working in their settlement program. For example, the Washington field office has this program called WISE, and then they have certain mediators within that program that mediate the case. All that is told to the judge trying the case is that either the case settled or did not settle. Anything discussed during the mediation does not go back to that judge. But a judge can order you to do that, and you have to engage. Even if the result is not successful, you have to engage. If you present a reasonable offer and then the agency comes back with $2 and a bus ticket, you don't have to agree to that. You move forward. However, if the agency comes back and they're willing to go back and forth, that is a process worth engaging in, because at the end of the day, if you can get an outcome that allows you to walk away from your case and be satisfied, you should do that. Remember, it's settling. It's not winning, settling. That's a key distinction. There is no, like I said, there's no requirement to settle your case, but you may be required to talk to the judge about specifics of demand. I prefer not to do that, but a judge could tell you you have to try to see if they can resolve the case in that initial status conference. Even if the case doesn't resolve prior to the start of discovery, at any point in the case, you could resume discussions. So let's say a deposition, well, it could go either way. Let's say a deposition did not go well, and you want to keep talking about discovery or settlement with the agency, or a deposition went really well, and you think that the agency is now going to be probably more inclined to talk settlement. You can engage anytime during that time, unless you request from the judge to stay deadlines. Those deadlines are going to be in place, which is why I call them parallel tracks, because your deadlines are still going to keep moving forward, even if you're having settlement discussions, unless you ask the judge to stay those deadlines. So be mindful of that. Having settlement discussions does not waive your obligations under those deadlines. And settlement discussions are, negotiation is a skill. It is. And so it's one of those areas that would be a great spot for an attorney to properly convey your settlement demands with the agency and potentially come to that resolution. I find that having, and this isn't just a self-serving statement, I find having a representative during settlement discussions helpful, because it is someone who is looking out for the best case scenario for you, but also isn't emotionally invested in it. It's someone that's not angry because they didn't live through the experience. It is someone who could represent you, but doesn't have an emotional investment in it. And that's one of the things you want to look for when you're talking about settlement. You want to find the best possible outcome that you can. And that may not be what winning is. But you want to make sure that whatever is the best possible outcome that you can get in the case, you get that. And if that's possible, but you're still rightfully angry about what happened to you, having an attorney at that process is very helpful. All right, next slide. I think now we're going to open it up for questions. Taylor can open it up, or Taylor, do you want to comment about whether people should submit questions during the chat or if they need to raise their hand.
Yeah, we're going to open any questions that anybody has, please submit in the chat, and I will send those over to Stephanie to answer. We do have a couple that were submitted, so I'll start sending those over now.
Okay, wonderful. And I'm just going to preface that I cannot answer questions that are specific to your case. So if you ask about something specific, I cannot provide legal advice to something specific. I can answer general questions about the process. One of the questions I have is, can witnesses that you want to invite as part of discovery deposition decline to participate? I think that means if you want to notice somebody's deposition, can they say no? If they are a government employee, no, they can't. Now, if you want to depose the Secretary of Defense, but the Secretary of Defense is not anywhere related to your case, no, you can't do that. But if the RMO, for example, says, I don't want to do a deposition, they have to. And they could be disciplined for not doing that. That burden falls on the agency, though. So you don't have to go after the RMO, you go after the agency counsel for failing to produce, and that might be a motion to compel you need to file for providing that witness to participate. So person added in that question is that witnesses might not want to risk being target and face retaliation themselves. Again, that's the difference between a friendly witness and a not friendly witness. A friendly witness who has positive testimony for you that fears retaliation may be better that they do an affidavit. However, I would say that participation in an EEO complaint, such as a deposition or providing an affidavit, is a protected activity. And if any action is taken against them because of that participation, they themselves now have an EEO complaint. So someone asked me about settlement. Do you have to sign a clause not to discuss settlement after the case is closed? Most likely, the agreement will have a confidentiality provision, and it'll say that you cannot talk about the terms of the settlement agreement. So if you got $50,000, you couldn't discuss that you got $50,000. What you could say instead is that I settled my case. The matter has resolved. Estimated cost of a court reporter for a deposition. It varies. I'm sorry, this is a very lawyerly answer. It varies. It varies based on the length of deposition. You have a 1-hour deposition. Obviously, the transcript is going to be a whole lot shorter than a 7-hour deposition. So it depends. Doing a Google search is a great way to look for court reporting companies, but there are quite a few court reporting companies you contact. You can ask for a cost estimate, what their court reporting fees are versus and their transcribing fees. So i.e. Court reporter showing up for the day and doing the recording versus the production of the transcript, and that's usually something per page. So, you'd have to get an estimate. Some companies are more expensive than others, just like anything else. Does the agency have the power to subpoena documents from anyone other than the complainant? Well, again, if they are a government employee, technically any government-related document is in the possession of the government, not the specific employee. So if a supervisor keeps a file of memos, and the only person who would ever see this file is the supervisor, doesn't matter. That's the property of the government. That's not a personal file. That is the agency's. And so the agency can request that those documents be produced, and they should be. Now, I guess I should talk about what if someone is no longer a government employee. If someone is no longer a government employee, the EEOC does not have subpoena power. So unlike a court, where a court could require someone to come in even if they are no longer a government employee, the EEOC cannot do that. So if someone retires, unless they agree, you're not going to be able to ask them questions and get information. However, this is a double-edged sword, because at the same time, the agency is not going to have supportive evidence that they can rely on. They're not going to be able to rely on that person's testimony at a hearing. all they'll be able to use is whatever is in the ROI. So if your lead RMO retires and before they provide an affidavit, the agency doesn't have a statement on which to rely. Conversely, you don't have something to question. All right. So far, I think that's all. Any other questions? You can put them in the chat. I think that's all I have. I'm gonna hold it open.
Seems like those are all the questions, Stephanie.
Okay, well, I'm just gonna give a minute just to make sure someone's not typing up something that they, a longer question. But in any case, if you want to discuss, let's say you're headed into discovery soon, you want to discuss your case with one of our attorneys, you can contact us and set up a consultation with one of our attorneys to go over and to discuss representation, or during that consultation get advice. Discovery is a very cumbersome process. You have to relive everything. It's going through everything again. So it can be very taxing on you emotionally, physically. And so it may be a good idea to have counsel during that process, just to have someone supportive of you who is also taking some of that mental load and the physical workload off of you. Oh, I got another question. Is the agency case dropped if you retire? No, an EEOC case does not go away if you retire. There is no reason to stay in a job if you don't want to stay in a job just for the preservation of your case. It might change your damages a bit. So if you, wanted to be assigned to a different position, obviously, if you retire or you resign, that's no longer something that can happen. But no, your case does not go away if you leave the agency, if you retire, if you leave the government. If the complainant decides to withdraw from a case, is there any financial exposure regarding the agency's case preparation efforts? In grand majority of cases, no, there's not. I always leave open a tiny possibility if there's particularly if you're in federal court or something, but no, if you drop a case at any point, typically before the EEOC, there would be no financial obligation. What I would say instead is you would withdraw your hearing request and request a final agency decision. Do EEOC case results go into your personnel file? No, they do not. Nothing related to your EEOC case goes in your personnel file. And most cases, even when made public, have aliases associated. So unlike federal court complaints that you file and you Google, you can find them. Most likely with any EEOC case, you're not going to be able to find your name. It's only going to be the people involved. The agency is going to know about it. And mostly that's general counsel's office is going to know about it, but no one would find it in your personnel file. Does the EEOC go away if agency files for bankruptcy? That sounds like a very complicated question. Typically the federal government isn't filing for bankruptcy, so I don't know. That might be something warranting a specific consultation to go over. And then someone asked, is a settlement option for the agency to facilitate a position transfer to another federal agency? I always say with settlements, you can ask for anything. You could ask for a red Corvette. Are you going to get a red Corvette? No, but anything's a possibility. Most likely, something that would be inside the realm of another government agency is not going to be something that your agency could agree to, but it doesn't mean you don't talk about it. Maybe there's a relationship. Maybe you're under the same umbrella parent agency and you could transfer in the sub agencies. It's still something that you might want to talk about. It's worth having the discussion. Can I ask for emails and timesheets for people in my department? Only as they relate to your case. So if you're being accused of cutting your time, putting in a time card for time you didn't work, and Bob Smith did the same thing or is actually doing it, you could ask for Bob Smith's time cards under a specific period of time. You can't ask for just kind of carte blanche. Now, emails that say, you know, Bob Smith was talking to the RMO in some manner, and you think it might be discriminatory in emails, yeah, you can ask for that. Another fun thing to ask for is, you know, most government agencies now have an inner chat system. Those chats are typically stored, at least for some period of time. You can ask for some of those between employees. All right, see if another question's coming in. Oh, I think those are all of the questions. All right, I want to thank you all for attending today's presentation. I hope it has been helpful. Again, if you have any follow-up questions or specific questions about your specific case, please feel free to reach out to us, and we're happy to talk to you about it. And I hope everyone has an excellent afternoon. Thank you all so much.